Okay, so we had done till here the difference between fine and penalty. Now in continuation, just remember for the particular criminal laws, they have actually, we know that the three laws have been separated, right? We know that the IPC is the BNS Act, the IPC is the new BNS Act, your CRPC is the BNSS Act, and your Evidence Act is your BAS Act. Okay. Now in the supplement sheet what ICSI has given you, they have mainly covered only these two. They have not covered the Indian Evidence Act. So we will do the entire supplement sheet. And remember one thing, that they have not drafted it that well. What I am going to teach you is in a very synchronized, sequential manner. So first, I will finish all the aspects of BNS from the supplement sheet. So what they have done, they had BNS, then inside also they have put BNSS, then again they write about BNS. So it becomes very confusing to learn the sections. So when you open the supplement sheet, you will get BNS, and then in between only they start putting about BNSS, and then they come back to BNS. So it gets very confusing for the students, especially to memorize. So what I have done, first I have taken all the aspects of BNS. I have put it down, and I will first complete BNS. Then all the aspects of CRPC which is there, I will cover it in a separate video. Clear? So let's begin. Okay. And obviously I am making these notes. It's very nicely made notes. All the keywords are highlighted. And nothing the student has to do. All the complicated things I have simplified with my own examples wherever it is needed. Okay. So good to go. Can we start? You all can like the video, and we will quickly start with the session. Okay. So obviously everything is from the module and the supplement sheet. I'm covering every single thing. I can give you in writing. Not a single word will come outside the what I'm going to teach you, because I'm covering 100% of the content. Okay. Good to go. GTG in the chat box, and I start. Okay, so I know that I'm audible, visible to everyone. Right? Come on, quickly, just a simple little thing I'm asking. Audible, visible, GTG, and we start. Okay, so let's begin. Thank you, everyone. Soumya, great. Okay, let's begin. Hi. So now we'll start with the second or the next part of the BNS Act. In the BNS Act, we know it is the law of crimes. Okay. So when we say it is the law of crimes, we should know what are the fundamental aspects of a crime. Okay. Just a second. Okay. Fundamental aspects of a crime. Let's see. So all these notes for the students, obviously, who are enrolled with us, they will get the full notes, obviously, and all the lectures also very nicely edited. And for the students who have not yet enrolled, they want these notes. Any students who are regularly attending it, commenting, okay, all of them, they can, I will share it with them personally as well. Okay. Let's see. So you all can message me. I'm in the WhatsApp group admin. I will forward you once I've completed the entire notes. Okay. So let's begin. Okay. And the notes of this chapter only. Okay. Since I'm making it, and it's very important from exam point of view. Okay. Arvioli, great. Madhava and Vijangit, great. Nice. Thank you. Let's start. Hi, so we start with the next part, which is the fundamental elements of a crime. Now, a crime, as I told you, in the BNS Act, they don't use the word crime, they use the word offense in the act. But generally, we can definitely use it in our, language or to communicate it. So the crimes, in order for a act to become a crime, there are three important things that have to be there. First is it should be a human being. So only a human being can be tried under the law of crimes or your BNS Act. Second, it should be an act. There has to be something being done or omitted from being done for it to be prosecuted or to be punished. And third, you require a mens rea, a guilty mind, a intention to do the act to be guilty. So we will see all the aspects with the exceptions in depth. So three important fundamentals requirements are there of a crime. It should be a human being, you should have the guilty mind, and you should do a wrongful act. First, let's begin with each one. Now you tell me, can we catch this cat for killing the mouse? Obviously no. If a animal, when you see a bull is running and it hits someone and it kills someone, will they be held liable? Answer is no. So obviously only human beings can be tried. Okay, even if let's say there is a ferocious animal, it goes and it bites someone and kills the person, the owner can be held liable but not the animal, because the first important component is it should be a human being. So the commission of a crime must be committed by a human being first. Next, human beings have a responsibility to act in a certain way. That is called as a legal obligation, that we are expected to act in a certain way. We are expected to drive in a rational manner. That obligation is not on anyone else other than human beings. Okay, so only a human being under legal obligation can be punished and not any animal or any other thing. Next, okay, mens rea. Now what is mens rea? And it's very very interesting. And you tell me, mens rea, we've always been learning that mens rea is required to make a criminal act. However, nowadays courts are disregarding mens rea. We'll see the exceptions also, where you don't even have a guilty mind, still the it's called the exceptions to mens rea. In even when you don't have the intention, you can still be held liable under criminal laws. We will see, but we'll see the base rule first. The base rule is that actus non facet reum sit rea simply means that the act itself does not amount to being wrong, being guilty. The act must be accompanied by a guilty mind. So simply the act itself will not amount to the crime. It has to be accompanied by guilty mind. For example, let me give you a simple little example. So example is of a firefighter. So what happened? There was a building. Okay, there was a building, and this firefighter was, he saw that their building is on fire. The building was on fire. He ran up because he saw that someone was stuck on the 13th floor. He saw that there was a small child that was there, who could not be removed at all now. So her life was at risk. So he had no option but to throw the child down. Okay, he threw the child down, and unfortunately nobody caught the child, and the child died. Okay, now will the firefighter be held liable? He ultimately murdered someone, right? So the answer is no, because he didn't have the intention to kill that person. Okay, so it cannot be held liable unless you had a guilty mind. Next, mens rea is a mental element, a attitude, okay, which will constitute a criminal liability. Only when you have the attitude of, or the mentality of doing the act, then only it can be held a crime. Mens rea is judged from the external act of the wrongdoer by applying certain standards. So how will we determine we can't open the mind of a person and see whether he had the intention. We will determine from the external conduct. Okay, of the wrongdoer, and then we will decide whether he had the intention or not. For example, if we load a gun, I point it at someone and I shoot him. So from my conduct, it is very clear that I have loaded the gun, I was in anger, I saw the person and I shot him. So the intention can be assumed from the body language. Now, there are types of mens rea. Okay, there are different kinds of mens rea. So mens rea is called in different ways. Again, in your entire criminal laws, again, BNS Act, they have not used the word mens rea only. Mens rea itself is not used. Instead, they use the words mens rea word is not present in the entire criminal law act. It is not mentioned. Instead, what do they define? They write the word you had the intention. You were negligent, gross negligence, or you were extremely reckless. All these three things deem that you had the intention. Okay. So if I have acted extremely reckless, it means that I was, reckless driving deems that I had the intention to harm someone, because if I'm driving recklessly, law presume that I had the intention. I was so careless, so negligent that I could end up killing someone. Gross negligence is also there, where a doctor is there. Doctor was required to do some things as per the standards. He was ignored. He said, it's my wife's birthday, I have to go and celebrate. I cannot go. Neither did he call anyone to take care of the patient, and the patient died. So the doctor can then be tried under criminal laws, though he didn't have the intention of killing, but he was extremely negligent, which any person in his field would have taken care. And the third one is intention. So let's see, what do you mean by the term intention? So intention is having a proper purpose, okay, or design with which the act is done. So intention means you had the purpose to do the act. Intention means a position of a mind, a condition of someone, a will of the accused. So intention could be mean the will of the accused. The accused had the will to kill the person. Okay. Criminal intention does not mean any specific intention, but a general intention is also sufficient. Now, what does this mean? That you don't require specific intention, generic intention is also covered. Okay. For example, I in a fight between husband and wife. Now, this was a real case was there. What happened is the wife was continuously talking, you're not good, you're not earning, you're not doing anything. See the neighbor, he's gifted his wife a jewelry, he's gifted the wife the mother is also so nice, your mother is also not taking care. And then the husband got he was extremely frustrated. He took a sword and he threw the sword on the wife. The wife was very athletic, so she went down and the sword kept it flung and it kept spinning and it went outside the window, and someone down, they all were looking at what happening, the fights, they are looking at the fight, and the sword hit a roadside viewer and he died. A roadside person was standing looking at the fight, he died. Is intention there of the husband of killing that person? He wanted to kill the wife, but they say no, you will still be held liable. Why? Because throwing a sword or a knife is such a dangerous act that you presume that someone could get hurt. So therefore this is considered to be a general act. I didn't want to kill that passenger, I didn't want to kill that person who was standing on the side. Okay, I wanted to kill the wife. Okay, but they say no, throwing the knife itself could be covered. So here they've given the example of poison. You try to poison the food but someone else ate. So then you can still be presumed to have the intention of killing. Who killing, it doesn't matter. Okay, next, negligence. Now when you see terrorists, when they came in 26/11, they were blindly shooting. They didn't have intention of killing any specific person. A generic killing intention is also enough. Next, negligence. Now what do you mean by the term negligence? Negligence means not taking care which any person in that field would have done. So negligence is not taking care where is the duty to take care. Negligence or carelessness is a state of mind. Again, carelessness is a state of mind, okay, where in the absence of a desire to cause a particular consequence. So for example, there was a absence of the desire to commit a particular consequence. For example, someone had given me some let's say there was a caretaker of a baby. The caretaker was nicely talking on the phone. The baby's day out, remember? The baby crawls out, goes out of the window, walks somewhere else. Now, can the parents file a case, criminal case? Answer is yes, that you were so negligent that a baby went on the road. You didn't take care. So again, it's a standards of care which any reasonable person in that field would have taken, and you fail to take reasonable care. Okay, and in such case, negligence can amount to intention or mens rea, that you have the intention. Third, being reckless. So I can say simply, rash driving. Rash driving. So when, or maybe drunken driving. Okay, drunken driving. So in that case, what they believe that you were so reckless that you knew that you had alcohol and still you are driving. So you were reckless. If there is any injury or any loss or any death, you will be held liable. So recklessness occurs when the actor, the person, does not desire. The drunken person didn't want to kill anyone, but he knows that drinking could cause potentially a loss to someone, and that happened. Okay, total disregard of the consequences of one's own action is recklessness. You don't care of what will happen with your action. Recklessness is a form of mens rea. So we saw that types or forms, what we'll write, forms of mens rea, very very important. There are three forms: intention, negligence, and what was the other one? Recklessness. Okay, INR. Intention, negligence, and recklessness are all covered under forms of mens rea or types of mens rea. Now, we'll see a case, a judicial case of Giri Jha versus the state. Okay. The existence of which gives criminal you to act is this. Well, let's see. That mens rea is a loose term of a elastic significance and covers a wide range of mental status and condition, and the existence of which gives criminal act to a particular thing. So let's understand what does it mean. In this state, what it was held, we'll write it in simple words, the meaning. That mens rea, simply meaning mens rea is a wider term, includes, it covers a wide range of mental situations, okay, which are there. As we saw, mens rea means guilty mind, but intention is also covered, negligence is also covered, and so INR is covered. Okay, INR is covered. Intention, negligence, recklessness is covered, is what they are giving. Clear till here? So in Girjanath versus state, it was held that mens rea is a wider term. It covers a wide range of mental conditions. A wide range of mental conditions. In the entire, as I told you, the BNS Act, the Bharatiya Nyaya Sanhita 2023, they don't use the word explicitly, they don't use the word mens rea. What do? They use it as a concept, that it's a concept in law, and they use the word such as BNS will obviously use, okay, they will use intentionally, voluntarily, fraudulently, dishonestly, maliciously, knowingly. So they use these kinds of words to show that you had the intention, that you were voluntarily doing it, that you fraudulently did it, or you dishonestly did it, maliciously, all meaning the same. So is the word mens rea written? No, it's a concept. Words actually used are intention, voluntarily, fraudulently, etc. Okay, and then the third part is, okay, the third element is act. What we were doing, we are doing the fundamentals of a crime. First of all, you cannot hold a animal in prison. It's only human beings. You need to have mens rea. Mens rea is very important, and mens rea, forms of mens rea has been given INR. And now we'll see the act, the wrong act. Now what do you mean by a wrong act? Okay, so let's see. So we had seen that the word wrong act simply means a crime. But the word crime is not mentioned. What do they write the word? Offense. Offense. Okay. So actus reus means, refers to actual commission of the wrongful act. So when you commit the crime, it is called as a actus reus. Either you voluntarily do or do an omission. For example, gross negligence, when it was duty to care, you didn't care. A doctor was extremely negligent, is a considered that you have, your omission did a crime. Directors, when they did not pay the taxes, it amounted to a crime. Okay, a harm or a legal violation. A crime cannot exist without an act, even if mens rea is present. Now obviously mens rea is just an intention, so mens rea has to be there, but just a guilty mind will not put you in jail. You also have to do some act beyond it, and then it becomes a crime. So what is a crime? Mens rea clubbed with a commission of an act or omission of an act will commit to crime or offense. Now very very important, okay, where I had told you all that now this mens rea concept is now losing significance in court. First of all, it is very difficult to prove the intention. Second, some acts law imposes that, listen here, if you did this wrong, we're not going to look into intention. The act itself is a crime. For example, I have a person has a lot of guns, bombs, and very dangerous chemicals in his house. So now what intention you need to prove? The act itself sometimes can constitute a crime where intention need not be proved. So now we will see exceptions to mens rea. Exceptions to mens rea, where in a simple reason is where mens rea is not required. So in all these cases, you can still automatically be held liable. Let's see. So mens rea is an essential element for most crimes. However, there are exceptions. There are certain exceptions which we will be studying where you can be liable without the proof of proving that you had a guilty mind. Simple. So the first one, it has come. It is called as absolute liability, where the law imposes a statutory obligation on you to do an act, and if you don't do it, automatically law will put you in jail, or you will be charge sheeted, or you will be a proper case will be built against you. Mens rea need not be proved. So for example, if you jump a signal, simple examples, you jump a signal, you break the signal, where intention, I must have really not looked at the signal, but they will say, listen here, statutory law has said if signal is broken you have to pay. We will not look whether you intended to break the signal or no. So statutory law imposes the liability, making the absence of guilty mind irrelevant. So this statutory law, the law itself is saying that the act is a crime. So this legal principle which we had, this legal concept that we used to have, that no mens rea, no crime, has been eroded in modern times. So this is no longer having that much importance as it had earlier. Many laws relating to public safety and welfare create absolute liability, meaning mens rea is not required. So in absolute liability or statutory imposition, mens rea is not required. As I told you, we'll see a few cases also, that if I am polluting the rivers, now intention is there to, and I am putting acid into the river and someone drank the water, they died. My intention was, but law says that listen, you have done polluting of a natural environment, etc., is a crime. In if it is there, then you will be held liable. So let's see in which all cases you will be held liable. Two cases I have already given example. Automatic criminal liability will be there. Okay, so motor vehicles violating any traffic rules, you didn't have the intention, still you will be held liable. Arms Act, possessing any illegal weapons with you, I already gave this example also. One very important that they capture is waging a war against the country. If you've waged a war, you've thrown a bomb on the parliament, so they don't need to prove, the act itself can put you in jail. Okay, public health, like for example, selling adulterated, dangerous food, food which have not got the necessary sanction, criminal intention will be imposed and you will be held liable. Drugs and pharmaceutical regulations. So sometimes they say that you should this standard should be maintained in the food quality. Now you didn't maintain the food quality standards and you still gave it ahead. You will be criminally held liable. Licensing violations, operating a business without license, you could be held in a criminal law. Jail can also be given. So now obviously it doesn't always mean that jail will be given in crime. There are multiple other penalties also. Community service is there if for petty offences. A simple fine can be imposed, etc. So there are multiple things. Let's see the next one. Okay. Now, second situation where for minor offences where it is difficult to prove mens rea. So law says that now it's a minor offense. Okay, it's a minor offense. We want to settle the case quickly. Okay, in minor offenses, and it is impractical to do the research into your mind, etc. So then they have said that it is you're liable. In cases where mens rea is extremely difficult to prove, in minor cases, okay, penalty is there. Okay, rather than severe punishment, then law will, instead of looking into the guilty mind, the act itself, allegation itself is sufficient. If I'll give you an example. For example, a hotel is using a cylinder bought at domestic rates, okay, without paying commercial rates of cylinders are different rates. Now you catch the person, now he says, no, I didn't know, etc. They say, okay, fine, penalty will be there. Or another example is if the electricity in your house, you're doing some commercial activity and the meter rates are different. Reading rates are different for commercial and residential, but you are doing commercial activity, and when law catches you, they can put a penalty on you. Simple. Okay. Next is theft of electricity. For example, in all these places, what they do, for someone else's cable connection, they add it in their TV so that they also can watch cable, or Wi-Fi you have taken someone's. All these small little things, the fact that the act was done is sufficient. We don't have to prove mens rea, because it's very difficult to prove mens rea in all cases. Next is public safety. As I told you, polluting a river, nuisance, creating a nuisance on the road, could automatically be held liable under criminal laws without proving guilty mind. Causing harm, okay, law imposes strict liability. I give you example of this also. Polluting a river. So perfect example, if you pollute a river, you could be held under criminal laws. Even fines can be put and shutdown notice can also be given. Next, offenses without knowledge. I didn't know that I am trespassing. Criminal law can be put. I didn't know this was government property. Criminal law can be put. I didn't know that the signal was there. I didn't see the signal. No. So a person violating the laws, even if they are unaware, in certain cases will be caught. Best example is a foreigner. Foreigner comes into India, says, I don't know the law. I didn't have the intention. So knowledge. So best example here is a foreigner. He doesn't have mens rea. Doesn't have mens rea, but violated Indian law, will be held liable. So 4 cases they have given you. Foreigner, public safety, like a polluting river, okay, is also covered. Then next, if you go to see difficulty in proving mens rea, so here I can give you traffic signal. Now really the person must have not looked at this red signal and he must have moved ahead. Very difficult to prove. And the most important also, if you go to see here, is statutory imposition of the act itself having certain kinds of guns. Or what was the other points that we can see? Motor Vehicles Act, arms, public health, some points you can put up here. War against the government, okay? So all these things, law says that if you do this, we'll directly put you into jail or into a criminal prosecution. Now let's look at the next part. Now we'll look at the next part, corporate body and mens rea. Now you tell me, very important, that a company, can a company be criminally liable? Yes or no? I just want to know you from your criminal laws and your corporate understanding. Can a company face criminal prosecution? Can a company face criminal prosecution? Yes or no? Answer is yes. Sir, how can you put a company in jail? Company is an artificial person. So there was a concept that we had done. Can anyone remember which was the name of the concept that we had done? It was called as lifting of corporate veil, or another word for this. Anyone knows what was the other name for this, which was lifting the corporate veil only? It was called as the doctrine of alter ego. Doctrine of alter ego. Here what they say, that a company itself cannot commit a crime. It is the wrongdoers who are running the company who are committing the crime. So we have to lift the corporate veil, we have to lift the corporate partition, we have to lift the corporate corporate shell to see who are the wrongdoers behind, who are running the company, who evaded the tax, and then put them under criminal laws. So again, very important, companies can also be held under criminal law. Now what happened to the companies there? There is a death of an employee due to lack of safety equipments. So the director will be held responsible. So any person, okay, section 2 subsection 26 of the BNS Act defines a person. So what do they say? A person could mean company, association, body. So they are talking of natural as well as artificial person. So therefore corporation could also be criminally liable. Why? Because they use the word under section 2 subsection 26, they define the word person to include an artificial person. Now let's see imputation of mens rea to a company. So what we are saying, imputation of mens rea on a company means what? Application of criminal guilty mind on a company. So company follows. So in company law there is a provision called as alter ego lifting the corporate veil, meaning that the criminal intention of the directors etc. will be attributed to the company. So the criminal intention will be attributed to the directors of the company. Okay, so whatever we are saying that company has a criminal liability, so the attribution that we do to company criminal intention is will be further attributed to the directors. Okay, so who will be held liable? Senior officials will be assumed that they have committed the crime. Now let's see judicial interpretation. State of Maharashtra versus syndicate transport. It was held that whether a body corporate can be held liable for criminal acts. Now again, what was the name of the case? State of Maharashtra versus syndicate transport. We just saw under which heading it will come, that yes, company, alter ego, they can be held liable, mens rea. Depending on the nature of the offense, we will have to look at various factors. Not everything will be attributed as a criminal We'll look at the position of the officer, circumstances in which the thing happened, what was the, if they really wanted to do the act, or whether they were really trying to, should we attribute the criminal intention to the officers. So for example, lack of safety equipments, lack of safety, minimum safety equipments, and someone died. So the criminal intention can be presumed. Now they have given you, after this in the BNS, we will be seeing the various kinds of penalties and offenses given. Very, very important. Okay. First, we will be seeing under the BNS Act what is theft. Then we will see what is snatching. Then we will see what is extortion. Okay. Then we will see what is robbery. Then we will see what is dacoity. Then criminal misappropriation. 8th is criminal breach of trust. 10 is retrieving stolen property. 11 is cheating. 12 is forgery. 13 is defamation. So we can say that 13 offenses have been given that we need to know. 13 offenses, out of which one is always expected. Out of which one is expected in exam. So we need to know one, and 5 marks is secured. So let's begin. Okay. So all these offenses that we have said is your offenses against property. Just say. Okay. So we'll start this part also. Okay. Till here everything is clear, yes or no? Till here everything is clear? In the chat box, yes or no? Okay. Okay. Good to go. Is everything clear till now? Yes or no? In the chat box. Okay, great. So let's continue. Now we'll see the offenses against property. Now offenses under property are given under chapter 17 from section 303 through 334. All the offenses we will see, and these offenses could be offenses against movable property, immovable property. Okay, and normally this is what we are concerned with. So let's begin. The first major offense given under the BNS Act is called as theft. Now what do you mean by theft? So let's understand, theft always will be of movable property. Theft always will be of movable property. For example, there is a small, this is among the smaller level of offenses. Imagine, example is a pickpocketer. He comes, he steals your money and he goes. Okay, he steals money and he runs away. This is called as theft. So now let's see. First main important thing is, theft means he intended to dishonestly take anyone's movable property out of the possession of a person without the consent of the person, and moves that property, means takes the property out of, in order to take such thing, moves that property in order to such taking, is said to commit theft. So first thing is, there is a intention to dishonestly take the movable property out of the possession of someone, obviously without his consent, and then after taking it you will move it and further run away with it, is called as theft. So let's see, what are the elements? First, intention to dishonestly take the property. It should be movable property. It should take a person out of the possession, and it should be moved. Obviously, in order to take theft, you will, if someone is coming, they will take the mobile and run, right? So they will move the property also. Let's see. Next. Now they've given you a few explanations. Let's see the explanations as well. Now the first explanation is that a immovable property can never be stolen. Immovable property can never be immovable. You cannot move it only. How will you steal? Steal implies movement, right? Taking the immovable property from someone's possession and then further moving it away from that person in order to commit theft. So here they are saying that a tree cannot be stolen. However, once you cut the tree and it becomes movable property, then the fruits or maybe any branches or the wood could be, after cutting it, then it can be stolen. So while something is attached to the earth like a tree, it is not movable property, cannot be stolen, simple. However, once it is severed, once you cut it, then it is capable of being there. So example is of a tree. Once the tree in the garden cannot be stolen, but if you cut it down and then you can take the wood and the fruits and then run away, that is called as a theft. Second, explanation, severance and theft in the same act. Now sometimes you might have to sever in order to steal. So you need to cut in order to steal. Okay. For example, if there is a animal that you're trying to steal, the animal must be tied up. You cut the particular rope and then you take the animal. So the cutting, severing means to cut, is needed to do a theft. So sever means to cut. Then only you will be able to move. Now for example, even severing means a certain kind of movement is needed to take it away. For example, if I am trying to steal water, so I will open the tap. Maybe if there is oil, you'll open the tap, get the oil in your buckets and run. So that aspect of severing, of moving is required to actually steal the real article. So let's take example. Okay, if an object is severed and cut, moved in the same act, it is said to be theft. So you've cut it and then moved it. So maybe a mobile might just be kept idle, but sometimes something needs to be cut and then you take it. Now nowadays they have it, they wear it they wear a thing because when they go in the train, so they wear it here. So in order to do theft, you have to sever and then theft. So nothing, just involves one additional mehnat, effort, that is cutting. Person cuts a rope tied to a cow, immediately takes the cow away, will come under this explanation. A person opens a tap to steal an expensive liquid. Okay, the act of opening is severing and taking away the liquid is the movement. Together, both of them constitute a theft. Causing movement is important because you won't steal and then stand there and looking at the owner's face, right? So you will now take the goods and take him out of his possession. So if a person moves a stone placed in front of the car's wheel, allowing it to roll down a slope, if done with the dishonest intention, it is called as a theft. So sometimes you move something so that I can further clear or open the door, so I can take away. So that will also constitute theft. So that is all I could say. To commit theft, there are multiple acts that will happen: cutting, moving, jumping, dancing, all that will come. So a person to cause a movement is said to have caused a movement if they remove an obstacle, prevented the movement, or separate it from another object. So a car, okay, where it was stopped by a stone, you move the stone, automatically things go out. Okay, so that causing movement will also come. Moving an animal, same point. Okay, now moving an animal, to move an animal you might take a stick and you will hit and then the animal keeps moving forward. So even hitting that particular animal to move it is also covered, okay, to create the animal's motion. So theft essentials are what we'll see first. We'll complete this. Okay, a thief hits a horse cart. So not only the horse will move. So imagine there is a horse cart. Horse cart. So this is the animal. Okay. So this is the animal, and with the animal there is a cart of lot of goods. Okay. So what happens when you start? A person comes here and starts hitting the particular animal, and he steals not only the the particular horse, but also the goods on the carriage. So when you run away with the cart and the goods inside, if the thief moved the horse, here the thief has moved not only the horse, the carts and the goods, which all amount to theft. So the thief cannot say that, listen, I just took the horse and along with the horse the goods came. So you will be treated as a whole act. Simple. Explanation 5, that it could be express or implied consent. Now what does it mean? Consent for taking an object may be expressly given or implied. A shopkeeper hands. Now understand one thing, that I have taken consent, and can it be called theft? So I must have taken I must have taken a consent to look at the article. After taking that much consent, then I ran away. So that is called as a, hands over. And if the customer runs away, there is no consent for taking it permanently. So consent was taken for small thing, but then you converted after that thing, you did theft. So that is all covered. Situations. Now again, till here is it clear? So what are all the elements that we read? Let's read again. Okay. So first thing, there was a intention to dishonestly take away a movable property of the possession from someone. Okay, is said to commit theft. Now we will see what does not come out to theft. Now I'm just understanding that there is a intention to move movable property, okay, and then further move it. So let's see. Cutting down a tree, we already saw cutting down a tree is not considered to be theft, but after cutting it, when you take it away, you sever the tree and then remove it from the earth, then it amounts to theft. Same example as we gave before, that you cannot steal a tree which is attached to the earth. So immovable property cannot be stolen. Okay. Now the next is inducing a dog to follow. Now understand one thing. As we saw, we give food to the animal comes behind me, it is still be considered to be stealing. Why? Because the dog started moving due to the person's act. It will be treated as if the theft was done. Now situations which do not constitute theft. Okay. Let's see. What does not constitute theft? Selling entrusted property. Now there is a offense that we will see which is called as criminal breach of trust. So there is a separate penalty or a separate offense called as criminal breach of trust. So obviously if you are falling under criminal breach of trust, it will not be theft. Now what is criminal breach of trust? First, there was a trust given. There was a trust given to my agent or to my servant or to my brother. So I trusted the guy. So there was a trust. So the trust was broken. Trust was broken. So when theft was done by a trusted person, it comes under criminal breach of trust. So theft by trusted person is not covered in theft, but in criminal breach of trust. Clear till here? So that is why when you entrusted someone with a warehouse keeper, I gave the warehouse keeper and then he stole. So it is not considered to be theft. It will be treated as criminal breach of trust. Clear? So theft done by trusted person will not come under definition of trust theft. It will come under definition of breach of trust, for which there is a separate penalty. finding a unclaimed, same thing. It will be treated as if I found a particular thing on the road, okay, and I kept it for my own purpose. So it is not theft. It will be treated as criminal misappropriation, which we will see later. A finds a ring, okay, on the road. It was not in anyone's possession and he takes it. Since the ring was not in anyone's possession, it does not constitute theft. It will be criminal misappropriation of property, which is a different offense coming later on. Here, one very important thing, it should come here, okay. It must be taken from someone's possession. So when you find something on the road, you did not take someone out of possession. It was already kept there. So very, very important line here, that it has been taken out of someone of possession of a person. So it was taken out of a possession of a person. So if you find a finder of lost goods, cannot be treated under theft. The person will be treated under criminal misappropriation. Concept clear? Because the strict meaning of your theft is very different. Okay. Then you give the punishment. Now, punishment always for theft will be lesser as compared to all the other offenses, because theft is, given, and the others, when you will see, will be a little more, because there will be more things added in it. So section 303 is a person said to commit theft, when then he will be punished with imprisonment, which may extend till 3 years, or fine, or both. When he repeats the offense, okay, a second offense, now obviously he will get rigorous imprisonment for a term not less than 1 year, but which may extend till 5 years. So minimum 1 year penalty, so he will get only 1 year jail for returning. And if someone has stolen less than 5,000 rupees, very, very important. Now if someone has stolen 2,000 rupees, then they say what, jail and imprisonment, all that. We'll give them community service. Shall be punished with community service. So very, very, very important threshold is less than 5,000, then you get community service. First time offender, if you have done first time you've done wrong, you will get up to 3 years imprisonment. But if you repeat it second time onwards, when you do, then 1 year rigorous, so you will get only, and more also jail term can be given, but maximum 5 years. Clear till here? Simple. Then they have given you different cases, that if you've done theft in someone's house, then a separate punishment has been given. Okay. Obviously more will be given in 7 years. Clerk. Now sometimes what happens, your own person who's working in your companies, or peon, etc. is doing, then again penalty will be given of 7 years. Theft after preparation made for causing death or hurt in order to commit a theft. So you'll get a rigorous imprisonment, which may extend up to 10 years, and a fine. So theft after preparation for causing hurt or death. So for example, I have decided I'll punch a person and then I will take the money. So then you have obviously 10 years imprisonment. So theft clubbed with preparation to kill someone. Okay, so then that will be 10 years. Now we'll see a type of theft. First of all, it is a sub offense of theft. What? It is called as snatching under section 304. Under section 304. Now in snatching, what happens? Imagine they are riding on the bike, they take away your laptop, they take away your phone. Nowadays it's starting happening. Sometimes women are there, married women, they are wearing a chain, they snatch it and they run away. So this was never never a specific offense mentioned in the Indian Penal Code. This was the first time that they have added. So we have to first write it is a sub offense of theft only. You are doing theft only, from someone's possession you're taking dishonestly, you have the intention to dishonestly take movable property out of the possession of a person and then move it, run away with it, is covered as snatching. Let's see. So, snatching is a sub offense of theft. This is the first one. Now, what does snatching means? When you snatch, obviously it will be fast, quick. So, it will be offender suddenly, quickly, forcibly seizes, grabs or takes away from the possession or any movable property. It is called as snatching. Clear? A punishment for snatching is 3 years and which may also be liable for fine. Clear? Let's move ahead. So very important, snatching can be there, can be asked in the exam. So snatching means theft is snatching if in order to commit theft, the offender quickly, forcibly seizes, secures or grabs or takes away from anyone's possession any movable property. Then you are said to have committed a offense of theft. Let's see further. Now we will see extortion. Now very important offense also. In extortion, what happens? Can you see this? So obviously when someone shows you a gun, there will be a fear. Fear of what? Fear of injury. And if someone shows you a gun and tells you to pay 2000 rupees, will you pay, yes or no? Will you give 2000, yes or no? Okay, obviously you would get scared and you would have to give some movable property, okay, some valuable thing you will have to give. Okay, fear of injury, so then you will give. Now what is this? In extortion, very important, the person who is scared only gives. So the person who you were targeting, not voluntarily, but he delivers himself. He delivers himself without his wish, against his wish, but he himself delivers is very important. Let's see extortion. Now let's see the definition. Whoever intentionally, so they use the word intentionally. In extortion, you put a person in fear. You put a person in fear of injury. Or if I tell that, listen, I will kill you, is it extortion? Is this much part? Isn't there fear of injury? But I will say, I'll kill your child. Is that extortion? I'll kill the child. So obviously, even that is extortion. Intentionally puts a person in fear of injury to that person or any other. Obviously, if you threatened a family member, etc., and then induces the person to induces the person so put in the fear to deliver any article or any property, valuable thing, signed or anything signed, sealed, which may be converted into a valuable security, commits extortion. So let's break it down. First of all, there has to be an intention to put a person in fear. Second, you are dishonestly inducing that person. Inducing means what? Forcing, getting the consent of that person out of fear and to deliver any property. So now my question to you is, extortion can be done on movable or immovable property also, or both? Movable, immovable, or both? So obviously it will be either movable or immovable property is covered. Okay, I can tell you to sign certain papers and then transfer the bill. That is why they've said to sign anything also. If I tell, sign the property papers, otherwise I'll kill you, that is also extortion. Okay, and which I can later convert into a valuable security. So I make a document from which I will get a lot of money. I tell you, I put you at gunpoint and I say, act as my guarantor, sign as the guarantor for the loan. Out of fear you sign. So it is committing extortion. Clear till here? Now we'll see situations which constitute extortion. First, wrongful confinement of a child. A threatens that he will keep Z's child in wrongful confinement unless he signs a promissory note. Okay, any note I want you to sign, otherwise I'll kill the child. So Z signs and delivers the note due to fear, and A is guilty of extortion. It will be guilty of extortion as we saw. Next, threatening to plow up a field. So A threatens to send clubmen to plow up Z's fields unless Z delivers to a bond to them under a penalty to deliver certain goods to B. That listen, I will send goons, I will send mafias, I will send shootout experts, I will send your hitmen. If you don't give me, they'll come and they'll shoot you, your child, and they'll destroy your entire farm also. And then he gets scared, deduce, and he signs and delivers a bond under fear. It is said that extortion has been done. Simple. Yes. Now, types of extortion they have given you, and accordingly to the type of extortion, the punishment is different. So, a general extortion is when I just put a fear in you that you better give me the money, and you get scared and you give it. So, you get 7 years imprisonment, up to 7 years imprisonment. But if you are threatening that if you don't give me, I will break your bones or I will slap you 10 times, then you get up to 2 years imprisonment. Okay, here because you are threatening with injury, up to 2 years imprisonment or both. Okay, then a threatening or attempting. Now, threatening or attempting to threaten with death, then you get 7 years imprisonment. Then actually causing an act you actually do in furtherance, 10 years imprisonment. Okay, and last point is, if we do an act where I tell that I'll put a false case on you that you are the murderer. I will say that you have did a wrong to my sister in false. So I'm threatening that I will put a false accusation on you, okay, of a serious crime. So then up to 10 years imprisonment can be there. Extortion, falsely accusing someone for a serious crime, that it's 10 years. Types, we saw this. Okay, now one case law we will see. Jagdunan Singh versus Emperor. Okay, now let's see what was the crux of the case. Very, very simple. Now, the case was in Jaggunanandan Singh versus Emperor, that forcibly taking a thumb impression does not amount to extortion or theft, but constitute criminal force. Now you tell me, what is this? Forcibly taking a thumb impression does not amount to extortion. How does this happen? It amounts to assault. For example, I take your hand and with your hand I stamp on the paper. Is this extortion? Answer is no. Why? Because in extortion you are putting fear and he himself does it. So when so that person himself should, I get scared, I'm giving you the mobile. I'm getting scared, you take the money. Okay, in all those cases, then it will be covered. So, facts of the case: the accused, along with others, assaulted two people and forcibly took their thumb impression. The victims did not voluntarily deliver the papers. Here they voluntarily come and they give in fear. Then that is extortion. Issued involved. Does forcibly taking a thumb impression amount to extortion? So the answer is no. Can this be considered as theft? And what offense does it fall under? So let's see. First, decision of the court. Extortion was not established as the victims were not induced to willingly deliver the property. So they should willingly deliver the property in fear, then it becomes extortion. Put a gun and I say, you come here, put your phone in my bag and get lost. That is extortion. But if I come and I snatch it from you, that is not extortion. Okay, because you did not do. Is it theft? Theft was not committed as the papers were not taken from the victim's possession. So what happens is, in theft, another important thing was you should dispossess someone. Dispossession is important. So if the papers were in your hand, I took that papers from your hand, then it is theft. So I took a movable property from your. Now what happened here? I got the paper, I just took your stamp and I went. It was in my possession only. I forcibly took your stamp and I went away. So the act constituted criminal force or assault. So there is a separate provision that will be there. So the act constituted force, that punishment will be there. So for any offense to be fallen, it should be exactly those elements should be fulfilled. In theft, you will see that it is written that you have to take a person out of the possession. The movable property should be taken out of the possession. That was not done. Second, in extortion, I create a fear and then make you willingly deliver it to me. So that is also not happened here. So what happens is, in legal principle established, extortion requires voluntary delivery, as I told you, due to fear, and forcibly taking a thumb impression is not theft because it is a force. That would be a criminal force. Assault will be a different section. Now someone can ask in the exam also, what is the difference between extortion and theft? Now I'm just thinking, extortion is basically creating a fear and asking you to deliver to me. Whereas in theft, I quickly go take a pickpocketer. Just imagine a pickpocketer. He takes money from your pocket. So movable property taken from your possession, he's taken out of your possession and he ran away. Movement is there. That's it. So presence of consent. In extortion, you get the consent, wrongfully get the consent. In theft, there is no consent only. We don't take consent or anything. We quickly take the money and run away. In type of property involved, in extortion, both movable and immovable property is there. I can make you sign, tell you to deliver the property papers. Extortion could be there of that. Theft is only of movable property. So this is movable property. Theft is only of movable property, and here consent is also got in extortion. Clear? Now we see the next little offense, which is called as robbery. Now robbery, how it is different and how is it different from theft? So normally, sir, we feel theft is and robbery is same. So the answer is no. Robbery is a little higher form of theft. A little more penalty will be put. Let's see why. So in robbery, that is in your section 309 of the BNS Act. Definition, let's see. Definition, okay. So as per section 309, all in robbery, there is either theft or extortion. So in all robberies, now understand the term robbery from a new perspective as per the BNS Act. So whatever you know, remove that, now understand this. In all robberies, there will either be theft or it would be extortion. Means these two elements, one of them will be there only. So let's read the definition. So a theft will be turned into a robbery if you are committing theft. So all the essentials of theft you've done. Okay. The offender voluntarily causes death or fear of instant death. So can I say that in theft, when I come, you come with creating that I will kill you, or you create a fear of instant death. So either I'm doing extortion or I'm doing theft. Voluntary causes to attempt hurt, death, wrongful restraint, fear, instant death, or instant wrongful restraint. Okay, so now let's see. Now we'll understand this slowly by slowly. First, let's read it up. Example: if while committing theft, the offender voluntarily causes or attempts to cause death, okay, or wrongful restraint, he will said to have committed robbery. So while committing theft if he voluntarily causes death or attempts to cause death will be said to be robbery. Second, when will extortion become robbery? Extortion is robbery while at the committing extortion, the offender is in the presence of the victim. So first, offender should be in presence of the victim and induces fear of instant death to him, compelling the victim to immediately hand over the extorted item. So here he has to be in presence of the victim. For example, if while committing extortion the offender is present before the victim and causes a case of instant death, wrongful restraint, he commits robbery. The offender is concerned is offender is considered present if he is sufficiently near to put the victim in fear of instant death. So maybe a phone call will not do. You are in front of him when you are ready to do. So a simple extortion could be, I'll give you an example. An email is sent. An email is sent that you better give me the money, or where Salman Khan is getting extortion request that you pay so much money, otherwise we'll kill you. It's a extortion request. So extortion will be there. But robbery is when you come in presence 1-to-1 and you're telling give me the money. So then it will be under the head of robbery only. So situations which constitute robbery: holding a person down to take the property. A holds Z down and fraudulently takes Z's money and jewels from him without Z's consent. Okay, it is called as robbery. Theft becomes robbery. Theft becomes robbery. Now next, why is it robbery? A commits theft and also restrains Z is making robbery. So I'll explain. But let's complete it, okay? Situation 2, where he does not commit robbery. Threatening to kill the child unless it pays money is paid. Now your child, A tells Z that your child is with my gang. He will be killed unless you pay 10,000. Why is it not robbery? Because obviously it puts in fear of instant death. Extortion unless Z puts in the instant death of the child. So let's see what it is. So first thing is, a robbery is a wider term. It could cover theft or it could cover extortion. Okay, it would have this or that. Here what is happening is, in theft you are clubbing it with a death threat. Okay, and here in extortion you are present before victim. Okay, then it will be treated under the head of robbery only. So let's take an example. A pickpocketer, you are going in the train, he pickpockets your mobile and he goes away and you didn't even come to know. That is theft, robbery or extortion. Quickly. Mobile phone was in my pocket. Okay. So I was looking out, someone came, flicked it and ran away. I didn't even come to know. It is robbery, theft or extortion. So obviously it will be called as theft. Second, okay, I was there, someone gives me an email. Salman Khan got a email or a tweet that I will kill you if you don't transfer so much money in this account. What is it? Theft, robbery or extortion? Salman Khan getting a death threat that if he doesn't pay so much money, then he will be killed. So then that will be extortion. Why? Because we are asking him to voluntarily deliver that money. It is extortion. Now we'll take a case of robbery. Robbery is a little further end, okay? In robbery what happens? You have done a restraint. For example, in your someone has come on the highway they have surrounded your car and they have said, come out of the car, come out of the car, put your head down. They put their head down and they remove all the jewelry, everything from their possession, they keep it in their pocket and then they all run away. So that is theft, robbery or extortion. It will be a theft in which it will be a robbery which has the essentials of a theft. So it's a bigger term, more serious offense that will be covered. Because you have not only taken a person out of possession, you also restrain them, hit them, done some more things other than just taking away the money. Robbery. In extortion, what happens? Ultimately, in front of Salman Khan, person comes, shows the gun, give me 5 crore rupees. So then that is extortion and robbery. Why? Because you were present in front of the person and then you committed extortion. So a robbery is either this or that, and it has the features. So obviously it can be put under robbery also. So here you have to be present before the victim and then you do it. So if you're present before the victim and then you do it, then that extortion is called as robbery. Clear? So then they've given separate punishments also. When you are committing on the highway, etc., all those things has been given. Now, we'll understand what is the next thing. All this time we were seeing a solo person coming and asking all these, offender coming. Now we come to a dacoity. Now what do you mean by the term dacoity? Very, very important. When 5 or more persons come to do robbery. Now in robbery it could be the theft or it could be extortion. 5 or more people have come. That is the most important thing. So all of them will be held liable for dacoity. So dacoity is when 5 or more persons jointly commit or attempt to commit robbery or robbery, and robbery means either this or that, where the total person involved, including those aiding the crime, is 5 or more. So anyone who is supporting, all of them will be counted in total. It's a full gang that is coming to do robbery. It is called as dacoity. Even the person involved, whether directly or just aiding, is guilty of dacoity. Means every person is going to be held guilty of dacoity. For example, there were 7 people. 3 said, "Arey, we were just coordinating. We were just talking on the phone." No, it was an entire together conspiracy all were doing. All of them will be held liable. At least 5%, they are trying to attempt to do robbery, and each person involved will be guilty of dacoity, even if I was just assisting. Next, a case law was given, Emperor versus Lakshar. Facts of the case: a gang of 5 or more dacoits, one of whom was armed with a gun, raided X houses. After looting, they shot and killed a villager while fleeing. So they entered in a house and they killed a villager while running. Court held that the murder committed while running away with stolen property was murder committed in commission of dacoity. Therefore, every dacoit will be liable for murder. So whenever dacoity is coming, all the persons are treated as one and all the equal charges are levied. Even if one killed, all will be under the charge of murder. This is how dacoity is there. So dacoity means gang, and every member of the gang will be put with the same amount of punishment. Okay, then we come to the concept of criminal misappropriation of property. Let's understand what is criminal misappropriation of property. Very, very simple. Someone else's property, I made it mine. It is called as criminal misappropriation of property. The key word here is dishonestly. The key word here is dishonestly. Let's see. A criminal misappropriation of property is under section 314. Let's see. Dishonest misappropriation of property. A criminal misappropriation occurs where a person dishonestly takes or converts another movable property for their own use. So someone else's movable property I converted for my own use without lawful justification. This is the second point. So I dishonestly convert someone else's property to my property. Okay. So let's say, for example, someone's book was there. I said it's my book. I converted it into my name. I removed their name and I put my name. I removed their label and I put my label. That is called as misappropriation of property. So in simple words, when we go to see that the definition is not given, definition has not been given, they've directly said what is a misappropriation. Whoever this I had covered as a meaning, I just put a meaning by myself. This in the act, definition is not given. Definition is not provided under the act. Instead, the section which is 314 and 315, they say that whoever dishonestly misappropriates or converts to his own use any movable property. Okay, so any movable property I converted into my own use shall be punished with either imprisonment, which may be not less than 6 months, but which may extend to 1 year. So movable property, first of all, it should be movable property. I converted, dishonestly converts to his own use. So it has been converted to own use is called as criminal misappropriation of property. Let's take an example. So initially I found someone's mobile. It's not criminal misappropriation, but I remove the SIM and put mine. Then it becomes criminal misappropriation of property, because first of all movable property and then I converted it to my own use. So mistaken possession, later misappropriation. Now pay attention. A takes the property belonging to Z out of Z's possession in good faith, believing at the time that it belongs to himself. Sometimes we have same mobile phone with same colors. Sometimes the dress might be two same things. So I thought it was mine, so I took it. So it is a mistaken possession. But after discovering my mistake, I dishonestly appropriate to my own use. He is guilty of the offense. Next, borrowing with implied consent or selling for personal gain. Now, they had Z goes into a library. In Z's absence, takes away a book without Z's express consent. Now there was a friend. So I know that the topper was sitting next to me. I took the topper's book. If he had the intention that he had given the implied consent, then he has not committed the theft. If I knew that my friend is there, he would have said that whenever you want anything you take. So I assumed, but I know that he's not given me consent. So that is a dishonest. So if afterwards he sells the book for his own benefit, he is guilty of the offense. Similarly, a joint owner of the horse. So obviously both can take the horse for a walk, etc. Both can take care of the horse. But one part owner sells the horse and keeps the full consideration. Then it is considered to be misappropriation of property. Misappropriation means what? That it belongs to someone else. You dishonestly made it to your own use. That is what it is covered. Okay, temporary misappropriation is not an offense. Okay, so maybe you found a note on the road, it is not misappropriation. But if you found a note with a purse, and in the purse you know that whose name, Aadhaar card, PAN card, phone number, everything is given. So after finding lost goods, okay, I come to know the owner and I did not give it to him, I kept it for myself. Then it is converting someone else's property for your own use. So obviously it is lesser penal provisions will be there. Finder's obligation to return the property, as I told you, it's his duty to return the property. He does not take or misappropriates it, is not guilty of the offense. So if a finder of a lost goods is not directly responsible unless he converts it to his own use, even after knowing the real owner. Okay. Finding a rupee on the road, not misappropriation. Finding a letter with a blank note and the mobile number, purse, everything, then that becomes misappropriation. Essential ingredients of dishonest misappropriation. First, dishonestly is very important because you don't believe in good faith. There is a lack of good faith. And second, you intentionally convert it to your own use or own funds. Two essential ingredients are there for this offense to be established. Property must be misappropriated, converted to your own use, and it must be done dishonestly. So two important things are there in this offense: dishonesty and property converted for own use. Clear till here? Okay. Then we'll see a few case laws given. Very simple. Case laws on criminal misappropriation of property. First, in Begiram Dome versus the Aber Dome, criminal misappropriation occurs when the possession starts innocently. It occurs when the possession starts innocently, but later becomes wrongful due to the change of intention or new facts. Okay, so he took possession of the property believing it rightful, then there is no misappropriation, but later when you came to know the owner, then you become this, which is there what we just discussed. Muhammad Ali versus the state. Mere lack of purchase receipt does not establish criminal misappropriation. Now there was a very interesting case, and they'd asked in the exam also that what happened. You tell me. The police found that you had 15 bundles of electric wires seized from the accused. Now just because the accused did not have the receipt, can we believe that he has kept it, or he has criminally misappropriated it? He'll say, no, 15 bundles of electric wire is there. So many people might have. I also have it. I don't have the purchase receipt. So court cannot directly say just on basis of that. However, neither the electric department or nor any other person claimed the wires were stolen property. Okay. The accused had bought them from a scrap dealer and did not have a receipt. The Supreme Court held that not having a receipt does not prove that he is dishonest and therefore cannot be liable under the section. Then comes Udair versus State of Jharkhand. A civil dispute over the payment does not amount to criminal misappropriation. So a civil dispute between a contractor versus subcontractor had a civil dispute. Now civil dispute, it is a contract act, go to the contract act, etc. The Supreme Court had contractual disputes are not a case of criminal misappropriation because there is no intention only. Money belonged to the contractor, not the subcontractor. There was no wrongful misappropriation and the criminal complaint was squashed. Here what happened in the facts, a contractor hired a subcontractor. After completion, the subcontractor claimed that the contractor received payments from the principal but refused to pay to him. So there was a principal, then there was a contractor, and then there was a subcontractor. So he said that he got the money but he has not paid me. So that is a civil dispute, not a criminal dispute. Now come to the next thing. One is, normally if a death is there, a person died. Okay, a person died. Now from that a person who is dead is called as a deceased person. So you steal, so a person can steal from deceased person. So if a person died, someone comes, takes his watch, purse, everything. So that all is a separate offense for which a law has given a punishment they have given. So it's a penal provision that how much ever punishment has been So what is it? That whoever misappropriates property and converts to his own use from a deceased person. So sometimes a servant was there, servant came to know that the master died, he took away all the, this section will apply if he's taken from the master. Okay, so the servant had taken, it was said that he can be tried under this offense. Okay, that is it for this part. The next offenses we'll cover in the next section. Thank you. Okay, till here is it clear? Yes or no? Everyone in the chat box. So Pradeepa has asked me that is it enough to study only the supplement for those 3 chapters? Yes, I'm covering the full supplement sheet. You don't have to worry. Beyond this, nothing will come. What I'm doing. Can you even tell me how this criminal laws will help in exam? Do we have to in the syllabus? Preeti, yes, you have it in the syllabus in your JIGL, Jurisprudence Interpretation General Laws. There are 3 laws which was there, which is IPC, which is CRPC, and the other one is your Evidence Act. Now, instead of this, you have to do the 3 laws, 3 new criminal laws. So from your module, don't do IPC, CRPC, Evidence Act. The new law which I am doing, I am going to cover it in the next 3-4 days, and that is it. All in depth will be done. Okay, so that is it. Don't forget to like the video also. And Kati Roli, nice. Thank you so much for your kind words. I will see you all tomorrow with the balance part of the chapter. That is it, guys. Thank you so much, and don't forget to share it with your friends and like the video also. Vijan did great. Madhava, great. Thank you so much. Great stuff. So from the supplement sheet, keep doing the markings, and for all the students who have attended my live lectures, all of you all, I will give you all, after this is done, the notes, I will give you all these notes also. That is it. Okay. Thank you so much, guys. Bye.